I'm going to be discussing how cognitive processes influence jurors in a criminal case. I want to give a quick content warning because the cases that I'm going to be discussing involve sexual assault, rape, and discrimination. The gods of justice are tasked with determining the fate and guilt of individuals, and as simple as that sounds, in a court of law, the gods of justice are the 12 individuals in a jury box plagued with human error. The right to a trial by jury is given by the 6th and 7th Amendment. However, the use of jury trials is decreasing as time goes on, as most criminal cases resolve as a result of plea deals or the choice of a bench trial with a judge as an alternative. Today, trials only occur in approximately 2% of federal criminal cases. In order to understand the issues corresponding with jury verdicts, we must understand how the jury gathers information and processes it. The science of decision-making consists of a combination of probabilities, assumptions, and prior experience in hopes of achieving the correct choice. The jury receives information not as a linear string of events, but pieces of information that must be combined and weighed appropriately. This often includes conflicting evidence and conflicting testimony. After weighing the evidence, the level of probability needs to be beyond a reasonable doubt. This dump of information begins with opening arguments, where counsel has the opportunity to provide the jury with an outline of what they should expect to hear and see in the case. The attorneys will set the expectations in a persuasive way, describing what the testimony and evidence will show in their favor. After opening arguments, the jury will see the evidence and hear the testimony from witnesses, all while meticulously weighing the information presented. This is where things can go wrong. This can lead to an inaccurate remembrance of information, conscious or unconscious bias, flaws in deductive reasoning, and improper application of heuristics and schemas. The brain can process information in several different ways. Two of these ways are by using in-depth analysis in order to form opinions, requiring more critical thought, and the other relies on heuristics or mental shortcuts that allow the brain to make inferences based on information the brain already has. One of these methods requires more concentration and energy, but results in a more well-rounded and reasoned opinion. This can be damaging when an individual is possibly determining the life or death of another individual. In a study conducted by Cassandra Fleck and Judith Platania, sought to determine whether the complexity of the case and exposure to pretrial publicity would affect the jurors' liability, decisions, and damages awarded. The study was conducted with a mock jury analyzing different cases with differing levels of complexity and pretrial publicity. The results showed a lot, but I'll sum it up. When exposed to highly complex language, individuals were more likely to find the defendant not liable for damages. This shows a reliance on heuristic thinking rather than the more complex alternative. Higher language complexity, combined with higher image complexity, showed a lot more reliance on heuristics and negatively impacted the ability to recall information about the trial. Higher complex language, combined with negative pretrial publicity, influenced how much damages were awarded to the victim. Results showed an increased amount of damages awarded. The study concluded that an increase in required complex thinking actually lowered the amount of critical thinking that jurors did and allowed for them to rely on preconceived notions rather than the facts right in front of them. Another influence of the decision-making process is based on schemas. So schemas influence our understanding of new information by drawing on all relative information the brain possesses in order to understand and interpret something new. When interpreting information, people often use their own personal schema to form their opinions and give weight to certain evidence. The schemas have a wide range when it comes to an individual and can come from personal experiences and assumptions. An example is a woman who has experienced sexual violence, perceiving the elements of a case differently than a man who has not. A study from Mary Caitlin, Danielle Pigot, Kyle Scher, and Jonathan Villano, conducted on a mock jury, examined how the use of schemas influence perception and the recollection of case details. The study consisted of mock jurors receiving a hypothetical sexual assault case to analyze. One group was given a case that conformed with the typical schemas associated with sexual violence and rape myths, while the other case presented evidence that was congruent with the typical schemas. Examples of these include alcohol consumption, how the victim was dressed, whether they were in public, in private, or the relationship they had with the offender. The goal of the study was to see whether the information presented was more accurately remembered by individuals presented with facts that match typical schematic material associated with the case. So results showed that the group given the expectancy-consistent case had a greater ability to recall information. This shows that schemas can actually cause retrieval errors to occur when facts presented don't align with the schema that the individual has in their head with the material in front of them. Typically, this results in the individual replacing the information with information that would be typical in that schema. When considering how bias can impact jurors, there are two types of bias that I want to highlight. The first is forensic confirmation bias. Oftentimes, the jury will rely on expert testimony in order to understand complex forensic evidence. These experts are often paid for their testimony by either the prosecution or the defense, and often support whichever side has paid them to be there. A study conducted by Jeff Kukuka, Alex Hiley, and Saul Kassin discussed how forensic confirmation bias, which is the phenomenon where task-irrelevant information influences judgments on forensic evidence, and how that has contributed to over 600 wrongful convictions that stem from misleading forensic evidence. They conducted a study to determine whether testimony from a forensic expert with prior knowledge of a defendant's confession would be believed more than the testimony from a forensic expert without the knowledge of a confession, in hopes of the jurors being able to discern between who could be impacted by bias and who may not be. Interestingly, the results showed that while the participants found the examiner who wasn't exposed to the confession more convincing, they also stated that the exposure of the examiner did not have an impact on their verdict. The participants were no more likely to convict the defendant if the examiner had been aware of the confession. The examiners were also aware that bias affected their peers, but denied that they personally were vulnerable to bias. Many forensic examiners would deny being susceptible to bias, and the results show that jurors would believe those denials. Considering when the examiner admitted exposure to the confession, but denied the confession influenced their testimony, participants rated their testimony as more convincing. The results showed that the participants were aware of how confirmation bias could impact the opinion of the forensic examiner, yet were unable to recognize when the forensic evidence and opinions could have been impacted by bias. The results called into question how jurors weigh testimony and forensic evidence. Jurors may not have the ability to appropriately weigh evidence if they are unable to recognize when evidence and testimony may be influenced. The second form of bias that I want to discuss is racial bias. These biases can be implicit or explicit, and a way to alleviate these biases is through jury selection. So, during jury selection, attorneys have the ability during the voir dire to remove jurors if the attorney recognizes any bias during questioning. However, other than this, there is no uniform or effective way to address bias in courts, and this method of selection only addresses explicit bias. An example of how an intentionally biased jury resulted in the wrongful conviction is seen in the case of Walter McMillan, who was found guilty of first-degree murder during a bank robbery and sentenced to death. Due to the high level of publicity surrounding the trial, the defense requested that the trial be moved to a neighboring county. This neighboring county had a much smaller percentage of Black people. The prosecution called 3 witnesses who either saw McMillan standing by the victim or saw McMillan's truck near the address of the murder. One witness was able to identify McMillan's truck due to the numerous times he had been at his house to buy marijuana. This testimony was struck from the record. The defense then called 6 witnesses, all of whom testified that McMillan was not at the location of the murder, but at a community fish fry at the time of the incident. However, the credibility of these witnesses was called into question due to the color of their skin. The nonprofit Equal Justice Initiative and Brian Stevenson took over McMillan's appeal case and found that prosecutors' witnesses had lied on the stand and illegally suppressed exculpatory evidence during the time both Brian and EJI received death threats as a result of their work. McMillan's appeal was granted, and he was released after spending 6 years on death row for a crime he did not commit. The wrongful conviction of McMillan was a result of noticeable bias in the jury and was ignored by the legal system. McMillan went on to speak with other survivors at the National Conference of Wrongful Convictions and the death penalty, highlighting the errors in the justice system. So how can we ensure that jurors are giving proper weight to evidence and testimony? Due to the adverse effects of jury bias that's been seen in wrongful conviction cases, judges have been increasingly more aware of the possibility of bias and ways to discourage bias and encourage critical thinking. These ways include avoiding complex legal jargon that tend to confuse and overwhelm jurors. Research shows that jury deliberation can help alleviate confusion and bias, allowing for the individuals to communicate with one another and promote understanding. Other studies conducted have concluded that making race salient or less noticeable or important may be a way to combat racial bias, considering that jurors are significantly less likely to find a Black defendant guilty than when race is not made salient. When considering the testimony of expert witnesses, the jury should integrate separate pieces of information dependently from one another when DNA evidence is presented. The jurors must consider whether the evidence presented is reliable. Jury decisions are some of the most consequential decisions that are impacted by human error, and acknowledging the imperfections in our own thoughts and opinions is crucial for justice to be served in society. While lawyers are trained to be lawyers and speak directly to jurors, jurors are not trained in the tactics and the evidence presentation methods that attorneys use. Without the ability to critically analyze the copious amounts of information presented, jurors will often rely on assumptions and preconceived notions to form an opinion. While many of these individuals are chosen due to their lack of political and legal influence, this often leaves them very confused and feeling misled by the legal system. With the amount of jury trials reducing, many individuals may be unprepared when called for duty without the proper experience or training. Encouraging jury deliberation, critical thinking, and drawing attention to all possible bias can help alleviate some of the causes of wrongful convictions. Thank you.